Good morning. Welcome back to Morning at NTV. I'm Malaki Villa Odera, and today we're talking about inheritance rights in Uganda. And just to bring you up to speed, last week we had a story in the Daily Monitor, and the scramble by beneficiaries to manage the estates of the dead dominates the number of cases that have been filed before the Family Division Court in the High Court. And just to give you a number to it, the Makinde-based court has a total of 739 cases that have been registered of beneficiaries who want to obtain letters of administration to administer the deceased estates. Why are we having this trend? Do we have a problem? Many have tried to follow through with no success and given up. So to talk more about that, we have Alex Matovu, who is a partner at Signum Advocates. Welcome to the show.
Thank you very much.
739 cases that have been filed in the High Court, just for people to get letters of administration for them to be able to access the deceased estate.
Yes.
This trend is high. Why are we having this?
That's interesting. First of all, thank you very much for hosting me. It's rather absurd, yet it's the reality that we do have this number of cases in court. I think that much of the time it's based on the fact that people are not aware of many of these things that would help to solve this kind of problem. If people, for example, had wills in place, you would not have the process of letters of administration. As we will talk about, we'll talk about it during the program. A will, if there's a will, the process is a lot shorter. The process is a lot more straightforward. The bickering and the fights usually come in if there's no will. So I think that's why, for me, the issue of information and giving people information and equipping them with the knowledge that they need to have actually becomes a very big solution, because you have a court that has one judge, two judges, and with 739 cases. Now, that's a family court. For your information, it doesn't only handle letters of administration. It handles every family dispute, be it divorce, be it parentage, or any other family concern that may arise. So this is just letters of administration. Imagine how many other cases there are.
Exactly.
So you have a backlog of cases in our courts. You have a system that is clogged because of the so many cases that come up with very limited resources. So I think we have to participate in this, because it's just a general situation. Everyone will tell you our budget is not enough, and it's the reality. So I think that we as individuals, as Ugandans, if we take up the responsibility to make wills and do all this, I think it saves us a lot.
It saves us a lot. Just before we went on a break, we had Andrew Chamagero, who was getting views from the members of public, and most men in today's society still don't believe that a female, a woman, can actually inherit land from their father or whoever it is from the family. Why are we still having this? And yet the laws of the land recognize women to be equal to men.
I think that it's two reasons. Number one, it's a historical problem, a problem that is a society that is largely patriarchal. A society that largely presumes that it's only the man that has the capacity to make wealth. It's only the man that has the capacity to contribute to the well-being of a family or a society. And I think that's barbaric, clearly. The Constitution of Uganda, which is the supreme law, what we refer to in legal terms as the grand norm, says that men and women are equal. All people are equal before the law.
Right.
And actually says that there shouldn't be any discrimination against anyone based on their sex or any other basis of discrimination. The law also goes on, the Constitution also goes on to prescribe that where there's any law that contradicts or that is not consistent with the Constitution, that law is unconstitutional, and it can actually be challenged. Now, that process has been ongoing, and as we go through the program, I'll explain what has happened over the years to challenge some of these laws that I believe not to be constitutional. But the point is, to answer your question, it's largely the societal beliefs. The law itself cannot apply in a vacuum. The law applies in society. So society beliefs have a lot to do with how we shall actually begin to practice what we do.
Society beliefs. Actually, my producer is telling me that his judge, when he was about to die, gave his father and uncle land that is prime. And so for his aunties, they were just given the family house, just in case you go into a marriage and the marriage doesn't work out, then you have somewhere to return. And also the burial area that was just set to bury families and relatives. And so like you're saying, we've been living in a patriarchal society. Now, how can women then stand out and own their rightful place when it comes to inheritance?
Yeah, I think that's an important one. It should be a concerted effort. There's no single individual that is going to change everything at once. So one, it's a concerted effort, meaning that there'll be different stakeholders or players that need to make a contribution. Secondly, it's also a question of time. If we've lived in this for ages, how do we expect it to change in a day? But one of the things that have happened is that there are NGOs, or women organizations, or actually organizations generally that believe in the rule of law and equality before the law, that have gone on to challenge the laws. In 2005, for example, just to point out one of the cases, we have a case, Law Uganda versus Attorney General, that was filed in 2005 by an NGO, Law Uganda, to challenge most of the provisions of the Succession Act. Now, the Succession Act is the main, or the key law next to the Constitution on matters concerning succession, both tested and intestate succession, as we'll discuss. But they went to court challenging most of those discriminatory positions. There are very interesting provisions that, are in these laws, such as, someone say, the law saying, if a man passes on, okay, so it defines a person to actually be a man, which is unbelievable.
Yes.
If a man passes on, this is what will happen. So actually what these guys were challenging was very simple. What if it is a woman that has passed on and they have something to give away? Can they still follow the same law? And the court, instead of reading into the law to say where you have man, please, you can also read woman.
Yes.
The law, the court said we are not, the framers of the law, the parliament makes the laws. Ours is to interpret the laws and to ensure that they're executed in a constitutional way. So they actually declared most of those provisions unconstitutional. Now, what has happened over time is that from 2007, there's been advocacy and a push to see that the laws are actually amended. Because remember, the court has said we cannot amend. So they only declare them unconstitutional, and the parliament has to take on its obligation. But the parliament as well cannot start from the blue. It has to be a bill that is presented, either a public, bill or private members' bill.
Right.
Private members' bill would come from organizations or from individuals. If it's government coming up with it, in this case through the Administrator General's office, it would be a public bill. The government says we have a bill in drafting. For now, over 11 years, nothing has come out. So the NGOs have taken it upon themselves to say, you know what, let's come up with a private members' bill and have it fronted. We hope that next week, because I've actually participated in the process of working on the amendments. So next week we hope that it will be presented to go through the process, the 3 readings that it has to go through. But it really has to be support from all stakeholders. Like the one presented now is private, meaning there's individuals, there's private organizations that have taken it upon themselves. Then government also has to support, because parliament is part of government. Yeah.
Let's go back to still what women can do to step up and still be able to acquire and get a rightful place when it comes to inheritance. Does it then mean that it's important for a woman to have, if she's in marriage, to have her marriage legally registered and recognized by the courts of law or by the laws of the land, so to speak? Is it important? Can it help?
Yes, I think it helps. There's been, actually, that's an interesting one. There's been a debate on, suggestions that cohabitees should be considered as married. Why? Because again, the society challenge is that many marriages are not registered. Many marriages are not recognized under the law. So you can live with, the person you call wife for many years, and you have, a number of children, and the presumption in society is that that's your wife.
Yeah.
The law defines a wife to be one who has entered or contracted a marriage legally. And for that reason, it's important that actually we care. Especially as women, like you've mentioned, knowing that, this is a society we are in.
Yeah.
If the law defines a woman, or a wife to be a person who has, gotten legally married, then it's important that we actually push for it. Now, there are many types of marriages in Uganda, and you don't have to go through the very expensive process that people see.
Right.
There's customary marriages. Customary marriages are usually contracted, what we call introductions, kuhinjiras and kwanjulas in our society. But much of the time that also requires to be registered. The law requires that you register that marriage, get a certificate, because then it becomes evidence. Much of the time what you see is a simple introduction and things stop there. Actually, people are not even aware it's a marriage. That's one side of it.
Yes.
But there's also civil marriages. When you just go to the Administrator General's office and you have your marriage registered with a registry of marriages. That is also a process that is actually pretty straightforward. The weddings can also happen, but the reception is not the wedding. And much of the time, that's where most of, the monies and the budgets are put.
Yeah.
I think that we need to do everything we do with the end in mind. we need to begin to think of things in terms of the implication they will have. The children that we give birth to, what will happen to them? You know, what happens if there's a separation? What happens if there's all these things?
Correct.
Not that we want to, you know, to have separations, but some of these realities get to happen, and we need to think ahead as we go about what we do. Yeah.
You talked about testate and intestate succession.
Yes.
And this is where intestate is where there's a provision of a will of the deceased.
Testate is where there's a will.
Yes, testate is where there's a
Yes.
will. Intestate is where there's no will.
Yes.
Now, with the African culture we are still in, many people have not yet warmed up to the idea of going to get a will done.
Yes.
And so what are the importance?
Yeah.
What is the importance of this particular will, and what is the process? If today I wake up and I say that I need to protect the future of my kids just in
Yes.
case tomorrow I'm not there,
Yes.
where do I start?
Yeah, I think that's a good one. Of course, we've mentioned that it's necessary to have a will. Maybe we can, you know, just mention what the benefit is.
Yes.
We've looked at the statistics, and facts don't lie. 739 cases simply because there's no will or there's no clarity as to what should happen when someone has died.
Right.
That's the situation of intestacy. The fights, people actually kill each other. It's that bad. Even siblings, simply because there was no direction given by the person or the deceased on how their affairs should be dealt with. So a will essentially is the wishes of a person before they die, of what should happen when they die, concerning, put on the record, because you can't make a will verbally.
Right.
Ordinarily. So essentially that's where it all begins. It has to be written, it has to be a record, so that there's no dispute as to whether what you said or what you did not say. That's the first part. Then dying intestate, like we've mentioned, is basically where you have no will. The benefit of having the will, like I've mentioned, is it aligns things, offers guidance even when you're gone. But it also enables things to happen the way you want them, or you would have wanted them to happen.
So you still have control over your
Exactly.
estate even if you're dead.
Exactly.
But where do I
Yes.
start? Fine, you've
Yeah.
said it's all written. Today I want to wake up and go get a will. Do I
Yes.
have to get a lawyer first?
Yes. I think that, yeah, I'll tell you why you would need a lawyer when you get to know the conditions. Some conditions are formal, some are substantive. What is substantive about the conditions of making a will? One, you have to have capacity. Capacity is both in age, but also in mind. So in terms of, you have to be an adult. You have to be an adult to be able to make a will. The second thing that should happen is that you should be of sound mind. So sometimes we've had situations of people that have become insane or senile. They are old and all that,
Right.
and then they are forced or unduly influenced to come up with wills. Such wills are challengeable. Those are the substantive requirements. The formal requirements are simply about how you come up with a will. One, the will has to be signed, and we require that the law requires that you sign every page. So that if there's 10 pages, you don't sign the last page, and then other pages are fixed, when you're gone and someone
Yes.
says this is your will. So you have to append your signature on each page. The will has to be witnessed, or what we call attestation. It has to be witnessed by a minimum of 2 witnesses.
Are they supposed to be family friends?
No.
Or
Anyone can witness,
that you trust?
as long as they're adults, and of course they are of sound mind.
Okay.
And they should have seen you signing the will, because the idea is they're witnesses. You cannot claim to be witness of something you didn't see
Right.
or hear yourself as it happened. So essentially that has to be to be able to happen. There's something that usually happens that people are not aware of. Contracting a marriage after making a will invalidates the will.
Aha.
Okay, that's
Okay.
that's something in the law that people usually ask, why is that even the case?
Yes.
It's actually the law, and I think the presumption is, of course, you had beneficiaries or children before you got married, or in the first marriage. Chances are high you'll have others in the next marriage, or when you marry, you would have to provide for your
Say that
spouse.
again,
Yes.
just in case someone has not gotten it right.
Yes, I need to say it because
Say
I had
it again.
it's actually based on a comment I had on one of the the people that were responding
Yes.
to the interview, and they mentioned they made their will long time ago and they don't have to change their will at all. Contracting a new marriage actually invalidates a will. Okay, you have to come up with a new will. If it's the same, it may be the same content, but let it show that it has been done on a date after the marriage.
It's an updated will.
It's an updated will. It's an updated will. So I think that's important for us to know. The will may also be invalidated because of the things I've mentioned, failing to follow the formal and the substantive considerations. For example, if we can prove that a person was not of sound mind at the time they made the will, or they understood whatever was drafted to be something else and yet it was another. Those are really the things that usually come up for a will to be challenged.
So a will can be challenged after the person who wrote it is dead?
Of course it can.
And on what grounds is that fair?
No, of
because,
course, yes.
Yeah, that's where now people who have ill interest and motives come in to challenge the will that is already there.
Yeah, maybe let me just conclude on then I'll come to that.
Okay.
Let me just conclude on the formalities of a will. So yes, you can make a will yourself, but the fact that it requires certain things to be in order, even the way it's kept. The way it's kept. Imagine a situation where you have one copy of the will and the person passes on and there's only one person who has the will. What are the chances what they're saying is true? Because the challenge with the will, unlike any other contract that we sign, is that we don't have the person who made it alive.
Yes.
And that actually introduces the discussion that you've been asking, why can it be challenged? Because you're not alive. That means there has to be a rigorous process to confirm that it's actually true. It's not as rigorous as not having a will, but it's a process. We call it the probate process. The probate process means that if, for example, I have a will, and we'll talk about what needs to be in the content. The content is, first of all, you have a testator.
Right.
Testator is the person who makes the will. The second thing is you have something that they are giving away. And that does not mean a will is invalid because there's nothing to give away. But usually we ask for what do you have to distribute. Thirdly, you have beneficiaries.
Right.
Okay. But there are many conditions, but I just want to specify the ones that are very critical to this discussion. There's what we call executors. So when I make a will and I have a piece of land, for example, and Mala is my daughter, the law requires that I appoint an executor who will execute the desires that I've placed in the will. Okay? So I will appoint an executor or executors who will first get onto the certificate of title before they can now transfer it to Mala, my daughter, if that makes sense.
Yes.
Okay. Now, the process of these executors being allowed or legally recognized is the probate process. So it is two things. One, to ascertain that the will is valid. Remember, the moment you say there's conditions to a valid will, it essentially means they're either met or not met. If they are not met, then it's not valid.
Right.
Okay? And that's the process of getting to know. That's why court intervenes. That's why after we've received the will, what we do is we apply to court to have probate issued. And the process is to essentially say where the signatures in the right places, are there witnesses, are there executors, and all that. Where you do not have a will, these executors are referred to as administrators. And the process there does not start with court. The process of intestate succession starts with the Administrator General's office, to whom you go. You have to have a discussion as a family to say we agree to appoint certain administrators, because there's no will appointing executors.
Right.
Where there's a will appointing executors, you go to court, mention that they're executors, you attach the will itself, and court will call them on board as well after confirming the will is valid to identify what we call the identification process. One, to know that they are, they are of age, they have the capacity, but also that they understand the responsibility that they have, because they're like trustees. If you've gotten crooks to manage your estate, and that's, again, what we've seen much of the time, once they are transferred and put on the titles, instead of transferring to the beneficiaries, sometimes they take it to their own, for their own benefit.
Right.
Yeah. And court wants to ascertain that they are the proper people and fit to be able to execute.
Okay. So let me give you a scenario.
Yes.
We have a woman. She's legally married.
Yes.
She has the marriage certificate. The husband wrote a will before he died.
Yes.
And at the date of death, the funeral, many other women come in with children.
Yes.
What happens next? Because fine, you didn't know these women exist, but these children belong to your deceased husband. Yeah. What then happens? Okay.
So maybe the question is, does not providing for some beneficiaries essentially invalidate the will? Okay. A will might be invalidated as a whole, or it might be declared invalid as regards to particular portions of the will. For example, if we find that it has gone through all the formalities, that you are of sound mind and everything was provided for properly, you have executors and everything, courts will rarely declare the whole will invalid. But if the beneficiaries that are actually your beneficiaries, because remember, an unmarried, legally married wife is not a beneficiary as such.
Right.
But the children they've given birth to are actually beneficiaries. If, of course, the DNA tests get to show that they're actually the deceased children, and so that can be done.
On the beneficiaries, bit of it, it's not a must for the person to
Yeah.
put down the names of the particular children that are supposed to inherit his estate.
No,
It's just a blank
no.
children clause.
No. The children have to be stated. That's why I mentioned beneficiaries.
Yes.
They have to be stated in name.
Okay.
Name, age,
So if
mother,
these children
everything
of
has to
this
be in
other,
place.
these children that come now to
Yes.
the fore during the funeral and they
Yes.
were not recognized in the will,
Yes.
what then happens?
If they are below 18, they're actually supposed to benefit.
From the will?
Yes.
Even if their names are not
Even
there?
if their names are not there.
Okay.
As long as it can be confirmed that they were children of the deceased.
Okay.
There's also what we call dependents. They may not even be blood relatives, okay? But if they can prove that they were partially or substantially dependent on the deceased, then they qualify as dependents. And for that reason, the invalidity will be only in respect of the distribution, because you cannot leave out your responsibility.
Right.
And that courts will intervene to say, you know what, there has to be a redistribution here and there. Okay? The will itself can be declared valid, but as regards the property, there can be a declaration to redistribute. As long as the beneficiaries that are found, they should be able to benefit.
They should be able to benefit. Wow.
Yeah.
So that's a polygamous situation that,
Yes.
I mean, we all need to get wills
Yeah.
and get out of that cocoon of feeling like if I get a will, because nowadays people
Yes.
say that if I get a will, it's like saying I'm going to die the next minute, and it's
Yes.
not so, so
Yes.
to speak.
Yeah.
Is the process of getting a will expensive? Because most of us shy away. You're an advocate and you
Yes.
help people get these
Yes.
wills.
Yes.
How expensive or how cheap is it? Is it affordable?
Yes. A will should be very, very affordable. And like I've mentioned,
What
not
is
everyone,
affordable?
Not everyone has to go to a lawyer to start with.
Okay.
I mentioned that. There's no requirement under the law that a will must be drafted by a lawyer. For as long as we can know what gets into the will, then it's important that we all have wills. I would start, for example, the very basic amount would be 500,000.
Okay.
At the very basic. And why I'm saying basic is that there's people that are not yet even married, or people that don't have children, or people that don't have so much property. Essentially, there's less time that we spend. Our tool in trade is time. So it's essentially the amount of time that I'll spend that determines, how much we'll charge. But it should be an inexpensive process. The question of when you should have a will, I think is also very important.
Yes.
I've had people, the people being interviewed and responding, and they say, I don't think it's time for me to have a will.
Yeah.
I'm not yet married or whatever. Or whatever I have will automatically go to my siblings and my family. It's not automatic, okay? Because one of the things that at times I think we miss out on is, one, no one exactly knows what is happening in your life apart from you, as perfectly.
Right.
So there's people that have died with properties that no one knows about. Now they presume that a will is for them, everything I have will go. Who even gets to know? How do we even get to know what belongs to you?
Yes.
So what a will helps us do is to start by saying, this is what is mine. Even if you're going to give it to your siblings or your relatives or whoever it is, let's start by knowing what it is. And I think that's the starting point.
Yeah.
Secondly, a will is not entirely about property. A will can be about burial arrangements. A will can be, the person who mentioned that it always goes to my family. We've seen people giving to charity.
Yeah.
Okay?
Yeah.
So the law does not require that the moment, a person dies, automatically things should go to the family. There are situations where you will say, you know what, there's a portion that I want to go to a certain charity. There's a portion that I want to support this foundation. There's a charity, a charity that I need to support. So essentially, let's exercise that right, because we actually have it. And we can only exercise it if we're alive.
If you're alive.
Yeah.
Wow. As you come to a close, tell us more about, we have the estate inheritance taxes that are normally levied by the government.
Yes.
Tell us more about that, because I think most of the times we are not, cognizant of that fact that fine, you've inherited this estate, but there are taxes, there are obligations to that. Tell us more about that.
In Uganda, we actually don't have what you'd call an inheritance tax as such. The laws we have are income taxes, stamp duties, and all other taxes that would normally apply when a person is alive. So I'll give you an example. If I had a property, a piece of land, and I died, in my will, putting on the executors or placing the executors on the title shouldn't be a problem. It should not attract any tax,
Right.
okay? Because the executors are my legal representatives. They represent me. If they transfer it to the children will also be taxed on income.
Okay.
Okay, if we're to talk about income tax.
Yes.
On income that they receive out of the property.
Okay.
Which is the same thing that would have happened if I was alive.
Okay.
So we don't necessarily have an inheritance tax. But we also advise that there's tax planning that is done. Okay, tax planning in terms of setting up trusts and foundations while you're still alive. There's money that you'd want to go to charity, and that money is usually not taxable. Okay, because it's not profit making; it is reinvested for the good of certain beneficiaries.
Right.
That's possible, but it's also only possible if you do it while you're alive. Yeah.
If you do it when you're alive.
Yes.
Wow. Thank you so much for coming on the show.
Yeah,
we would have gone on and on and on, but time is not on our side. There's also issues to do with insurance.
Yes.
Of the will.
Yes.
Maybe you can just have 1 minute
Yes.
to point out to the issue of insurance before we come to a close.
Yeah, insurance is simply about really life insurance. If you're to talk about insurance, it's in respect of life insurance.
Yes.
It's mostly planning for what happens when you're gone. And I mean, insurers can tell us more about this, but it's something as lawyers that we'd also like to advise, Part of, the prudence that it takes to prepare a will is the same prudence that it will take for you to think about what happens when you're gone.
Right.
In terms of insurance. So that's also something important. As to where you keep the will, a will can be kept with a lawyer, it can be kept with a bank, but usually advise that you have more than one copy, preferably 3 copies or more, and kept with different individuals.
Kept with different individuals.
Yes, because like I mentioned, if it's one person, chances are high it won't be believed.
Yeah.
But if it's 3 people saying the same thing, chances are high it's valid.
Thank you so much.
You're welcome.
We've learned a lot. That is an issue that is very sensitive and delicate for us, especially in Africa.
Yeah.
But now at least we are equipped with information. I hope you've learned a thing or two. In case you have questions, we have the social media platforms. The hashtag is morning@NTV, and he will follow through that thread of communication. And if he can, he'll get to answer your questions directly. Thank you so much for being part of this engagement. I'm Malaki Vilodera. Take Note is up next.